I'm attorney Shadi Schaefer from the Asset Protection and Elder Law Center, and I'm a trust attorney here in Orange County. Today I'm going to speak about the differences between power of attorneys for finances, because there's different types of power of attorneys for finances. But before I get into the details, I want to just briefly, I've explained it before, but I want to explain it one more time really quick. What is a power of attorney for finances? A power of attorney for finances is a legal document, for example, that I would sign, okay, and I would appoint someone as my power of attorney agent or power of attorney for finances. So this is someone that I would actually appoint that would act on my behalf when, for example, let's say I'm unable to make decisions and sign documents. This document really is for dealing with financial matters, financial accounts, and signing legal documents. So let's say I needed something to be signed on my behalf with the bank. This person, because I appointed them through this legal document that I signed and notarized, this person would be able to, in essence, go to the bank and sign the document on my behalf as if they were me, to help me with whatever it is that I'm needing to do at the time that I couldn't do myself. So that's sort of in a nutshell what a power of attorney for finances is. Now, there's two types of power of attorneys for finances. One's called springing and one's called a durable power of attorney, or immediate. So the differences between the two. One power of attorney says, okay, the only time my agent can sign on my behalf and use this document is when I am actually incapacitated and two physicians have certified in writing that I do not have the mental capacity to sign documents or sign things on my own behalf. So before that person could actually use that power of attorney document, they would actually have to get two physicians to certify in writing that I no longer have the capacity in order for that document to be effective and used, okay? An immediate power of attorney for finances is a document that from the moment that I sign it and I appoint that person to be my agent for my finances, my power of attorney for finances, from the moment that I sign it and I appoint, let's say, my sister, or I appoint my husband, they can actually utilize that document immediately. They do not have to get two physicians to certify in writing that that's a document that they can use. So an example of that would be if I'm in the hospital, something's wrong with me and I don't have the ability to sign documents, they can immediately do it. They don't have to get, proof that I'm incapacitated. Another example could be, let's say if I'm overseas in another country and stuck and they needed to try to use that power of attorney, they should be able to, in most circumstances, legally use that document and it is deemed valid. So long as the document's signed properly, it's got the proper legal language in there under the state that you live in my case, California, that power of attorney can be used. Now remember, when I die, the power of attorney, that document is no longer valid. So a power of attorney ends when you end. So it's just a document that is around when you're living, but you're unable to sign documents for yourself and on your behalf. Remember, married couples, just because you're married does not mean you can sign on behalf of your wife or your husband. So everyone needs a power of attorney for finances that's over 18 and over. Okay, so that's it for today. My name is attorney Shadi Schaefer from the Asset Protection and Elder Law Center, and continue listening. Thanks always.